All right, we are live and recording. Good morning, everyone. Welcome to the Judicial Proceedings Committee. It's February 17th, Friday at 9:09. And this is our voting session. So we're going to start off with Senate Bill 18. And I think, Jamie, you are counsel for that.
Senate Bill 18 establishes the Police Retention Work Group. The work group is tasked with studying matters relating to police retention. There are several amendments in your voting packet. I think the first one probably hits all of the aspects that the committee had raised at the last voting session. It would include one representative from the Maryland Sheriff's Association, one from the Chiefs of Police Association, one from the Law Enforcement Action Partnership, LEAP, one from the Vanguard Justice Society, members appointed by the Maryland Association of Counties, being a representative of a police department from an urban county, also one from a rural county, and then Maryland Municipal League would have appointments of their own for rural and urban departments as well. I would note one thing that is missing from the amendment that should have been in there. At the last voting session, the committee discussed striking the ACLU and replacing them with the NAACP. NAACP is not in this amendment, but we can add that in if the committee would like, just by hand.
And just to clarify, the ACLU is off by request, and the NAACP has been reached out to and they have accepted.
Correct.
No, just wanted to.
I think everybody's behind putting the NAACP on and taking the ACLU off, so I'd recommend we do that.
Okay.
Yep.
All right. Further discussion on the amendment, or the amendment's been adopted. Is further discussion on the bill as amended? All right, motions for favorable. It's been seconded. Is everyone okay? Unanimous. Okay. So Senate Bill 18. Yeah. Excellent. Senate Bill 18 passes unanimously. Sorry. Go ahead. Yes. Okay. All right. All right, we're going to go to 325, then we're going to go to 71, and then Shamari, we're going to come up to you with 191, 193, and 194. Okay. All right. So now we will go with Jamie Lancaster. Go ahead.
Senate Bill 325 establishes that the salary of the Washington County Sheriff is equal to 90% of the salary of the State's Attorney of Washington County. The bill also repeals the requirement for the Washington County Salary Study Commission to study and issue a report that contains recommendations relating to the salary of the county sheriff. There are no amendments. There is a delegation letter. It's the last page in your voting packet from the Washington County delegation.
All right, there's been a motion for favorable. It's been seconded. Is everyone okay? All right, the bill passes unanimously. 325 passes unanimously. All right, we'll now move over to Josh with Senate Bill 71.
Senate Bill 71 specifies that 25% of the net recovery by a debtor on a claim for workers' compensation indemnity benefits is subject to execution under judgment for child support arrearage, including any weekly benefits or settlement proceeds payable to the debtor. So under current law, 25% of a judgment on a claim for a personal injury is subject to execution. And there's just confusion as to whether a workers' compensation claim qualifies as a personal injury claim. The Court of Special Appeals had a chance to clarify that recently and resolve the case on other grounds. So, I mean, the testimony was that this is the general practice between the attorneys who represent the different sides, but because the law isn't clear, it just takes a lot of work to kind of get to where everyone agrees on the 25%. No, so the Court of Special Appeals had the question in front of them and resolved the case on other grounds. So it's still not settled law. There was no opposition. So that was MAJ. They just had some concern about the language that essentially says the bill doesn't limit recovery under the Federal Consumer Credit Protection Act. That was something that was amended onto the bill in last year's version. It doesn't really create any problems because that act also specifies 25%. Yeah, it is. So that they thought the language would cause confusion, but they haven't weighed in that since they submitted their testimony. They haven't said anything else.
Just procedurally though, so it was in last year's bill and then was in this year's bill?
Correct.
Okay, so their concerns were addressed through the language that was offered.
No, they think the language causes confusion.
Has it been, so have they? Nothing's been done to address those.
No.
Looking at it, they offered anything?
They just wanted it struck.
Yeah, I think we need to. Yeah. Can we follow up with them? Thanks. All right, we're gonna go with Shamari. We're gonna start off with Senate Bill 191.
Senate Bill 191 increases the number of full-time assistant sheriffs from 4 to 5. It allows the Fraternal Order of Police to negotiate benefits other than salary. It clarifies that sheriffs may investigate felony and misdemeanor domestic violence calls, and allows the sheriff to keep domestic violence investigations instead of turning them over to appropriate law enforcement agency. This is an emergency bill letter. There's a letter in your packets from the Prince George's County delegation. That should have been in the packet.
It's fine.
Okay.
Yeah, we voted for it.
All right, there's been a motion for favorable. It's been seconded. Is everyone in? All right, excellent. Senate Bill 191 passes. All right, we'll now move on to Senate Bill 193 with Shamari.
Senate Bill 193 establishes that a ground lease or an amendment to a ground lease that is not registered until it is posted on the State Department of Assessments and Taxation website. It also establishes a process for a tenant to challenge and bring action against a ground leaseholder who takes specified collection actions after failing to properly register a ground lease. A ground lease registration that has been voided by the State Department of Taxation is prohibited from being considered registered.
All right, there's been a motion for favorable. It's been properly seconded. Is everyone okay? All right, bill passes. Senate Bill 193 passes. We'll now move on to Senate Bill 94.
Senate Bill 194. Sorry, 194? Okay, Senate Bill 194 prohibits a leasehold tenant of an unregistered ground lease from being required to hold more than 3 years of ground rent in escrow. It requires a ground leaseholder to mail certain notices or bills to a leasehold tenant and requires the State Department of Taxation to make certain forms available on its website, and requires a ground lease transferee to send notice of transfer to the Department of Assessment and Taxation within 30 days.
The department, they want to be able to help people who've been caught in this situation. So they're helping to provide notice as well as ensuring that certain billing requirements are set forth. So again, they've been seeing issues and this is their way of just essentially trying to address it to essentially get and move away from these ground rents.
None of this works. Like if it's unregistered, then who's going to collect on it?
Yeah, if it's unregistered, they shouldn't be collected on.
Got it. Questions? There's a motion for favorable. It's been seconded. Everyone okay? All right, Senate Bill 194 passes. Senate Bill 56, Shamari.
So this bill prohibits a provision in a contract with the design professional for professional services that requires the design professional to indemnify or hold harmless the promisee's independent contractors, agents, employees, or indemnities, or any other person against loss unless the design professional is the proximate cause of the loss. This bill also adds highway or road to the list of contracts that a design professional may not be held liable, may not be forced to indemnify in the performance of that contract. The amendment that's in your packet would strike the prohibition against indemnity clauses and adds in number 5 on page 4, I believe, which clarifies that the bill should not be construed to prevent indemnity clauses that indemnify for defense costs of third-party claims, except as outlined in exceptions 2, 3, and 4.
Senator West, what was like the genesis of this? It's your amendment, right?
Yes, it was the engineers met with the Attorney General's representative, Mr. Kammerer, who has objected to this bill previously and tried to deal with his problems with it through this amendment. It just to deal with his concerns. So it's, and this year he did not come in and testify against the bill. It was the same written testimony he'd given in the past, but he didn't come in and testify himself. So my impression is that he's backing off he's not being noisy in his objection. And this was an attempt to even tamp down further his concern about the bill.
So this is their language or what better? He's aware of it.
Yes, he is aware of it.
There's no complication of those.
There's no, at this point, my understanding is he's never gotten back. He was provided with this and he never responded. So.
You don't understand what this bill is.
The best way this is very complicated language. The best way to explain it is my example of the concrete mixer backing into the highway work zone. And the concrete mixer backs over a worker. And because there were damages and loss and someone has to pay, the language in this contract, which the engineering firm that designed the bridge had to sign with the state in order to get the work, provided that the engineering firm would pay for any losses. So even though the engineering firm had nothing to do with the concrete mixer backing into the employee, the engineering firm ends up paying for the loss.
Even if you're a sub.
Even if irrespective of what the loss is, the engineering firm pays for it.
I mean, you remember those are smaller subs.
Right. Well, everybody on the job has insurance, except the engineering firm cannot get insurance to cover something that they had no connection with. So all of a sudden, this uninsured engineering firm has to pay for all the losses. And the argument is everybody ought to have their own insurance, so they ought to pay for all their own losses.
So everything you did on a contract.
Yes, for the small firms, especially minority owned firms, you're betting the business on if you bid on one of these contracts.
And so there was also the letter that the Attorney General said that generally indemnity clauses, at least by DJS contracts, they don't include them. And so Baltimore City, the Attorney General's office was concerned with prohibiting indemnity clauses entirely with these design professional contracts, because they would essentially be worried about incurring, because the party that most claimants would sue would be the state. And so these indemnity clauses for the state allow them to bargain and spread out the liability. And so that was the reason for asking that number 4, I'm sorry, I said it was page 4, it's page 3 of the bill, was stricken with the amendment language.
So that was interesting to me. Like, why were they the only city to come out against this? Because wouldn't this be true all across the state? Why is MML not interested or MACO not interested?
I don't know that information.
I think people should be responsible for their own negligence. And I think these indemnity clauses, what they're attempting to do is pass on responsibilities to third parties. I mean, yeah. And honestly, I don't think that they're fair.
And so they still are, under the law, responsible for their sole negligence. And those contracts that purport to relieve them of that are against public policy still. And that was the state of the law before this bill. But what this bill, without the amendment, does is prohibits those indemnity clauses for other causes of action.
So they're not acting as insured. Somebody else's negligence.
Right.
Yeah.
If as amended, however, or without the amendment, then those indemnity clauses would still be permitted.
Can I ask a question?
Yeah, sure.
You said sole proximate cause. So what, there's more than one proximate cause. How does this bill affect that?
Well, as written, if the proximate cause determination is a factual one that'll be determined by the court whether or not the party's negligence is the reason for the injury or the loss. And so it doesn't really seem to address multiple proximate causes. The bill as written would just address a proximate cause. So presume on just reading that, if they are one of the proximate causes that a court determines, then this bill would prevent a contract that purports to indemnify that design professional. So if that makes sense.
Sure if that did.
If you do that, then you can come back to us then. Okay, you want to go to Shamari? You want to, I want to give you a second to go to this one. So we're going to come up with Senate Bill 150. And in the meantime, let's do something that's
173.
Where's that one? Yeah, let's do 173. And then Shamar will come to you next.
Senate Bill 173 clarifies language enacted under Chapter 680 of 2021 regarding automatic expungements of records pertaining to charges in cases meeting certain criteria. In Chapter 680, in 2021, it provided that records would be expunged 3 years after a disposition of a charge if no charge in a case resulted in something other than acquittal, dismissal, not guilty, null pros, or other than a null pros with a requirement of drug and alcohol treatment. Basically, the genesis of this was that after the General Assembly passed Chapter 680, Mickey's, which is the publisher of the code, had designated, they actually designate the headers in all of the code volume. So if you read a section of law, a lot of times Mickey's will put in italics a description of what that section of law is doing. That doesn't come from the General Assembly, doesn't come from the bills that the General Assembly passes. It doesn't come from the Department of Legislative Services. What happened in this instance was Mickey's had designated the language as applying for automatic expungements as applying only to marijuana offenses, civil marijuana offenses specifically. And the language in the statute was broader and actually covered most criminal offenses and except for transportation offenses. But I'll just sort of leave it there for any questions.
Yeah, just a technical fix.
Yeah. Do you want to
Move the bill.
Okay, there's been a motion for favorable. It's been seconded. Is everyone okay? All right, so Senate.
Can I be added on as a?
Yes, all right, so there's been a motion for Senator Muse to be added onto the bills. Everyone okay with that motion for that amendment? All right. So Senate Bill 173 passes with amendment. Okay. We're now going to go back to Shamari. What did I say we were going to do? Which bill? Yes, let's get 150.
Senate Bill 150 alters the means by which the state treasurer may send notice of a denial of a claim under the Maryland Tort Claims Acts It authorized notices by email, or if the only available means is by regular mail, then the treasurer may send notice in that manner. If there's no notice that is sent after 6 months, the claim is deemed to be denied.
Any questions about this bill? All right, the bill has been moved and properly seconded. Any objections? Anyone want to be recorded in the know? All right. Then what was the number, Shamari?
150.
So Senate Bill 150 passes unanimously.
So there was no request for.
So I was good. No.
All right. Okay, excellent. So we'll hold Senate Bill 229.
Can I just say?
Excellent. Yeah, go ahead.
Senate Bill 29, there was a notion to make this 229, excuse me, make this a pilot program in the county of the sponsor, Anne Arundel County. She is amenable to that, but wanted to check with her delegation before we move forward. So that's why move for a hold.
All right, let's go to Shamari. Let's go Senate Bill 253. And then Josh, we're going to go to the judicial conference bill. No, actually, let's do that.
240.
Then we'll go to 240. Which one?
SB 40.
And then we'll go to Senate Bill. Hold on a second. Did Senator Carter want, I know you were in conversations with Senate Bill 40. Did she have? We're going to hold that one. Okay. I want to make sure she's available. So I don't want to do anything without her that she might be concerned with. Okay. All right. So Shamari, we'll go with that.
Senate Bill 253 requires a register of wills to accept any document electronically, except an original will that is filed electronically through a system established by the Register of Wills and in accordance with the Maryland rules. It does not prohibit the filing of a paper document.
I want to make sure that I'm clear on this because this was one I had a little. And maybe I missed it during. What was the verification? The Register of Wills, I guess my concern is that, and maybe this got answered, but is there a way to verify? Like, isn't there a requirement when you're filing a document with the Register of Wills that it's normally be notarized? Because it's such an important office. And then if we're allowing it to happen electronically, doesn't that kind of go in the face of someone that could have an ailing parent or something, and then they send the email forward and then all of a sudden there's a estate issue upon their passing because they changed the will of the parent?
So I guess that could happen, but the registers of wills in the different counties are empowered to create their own electronic system to deal with that.
So what I'm saying, Shamari, is that, and I know you understand what I'm talking about, but I just want to be very clear that because of the language in this, and I didn't see anything otherwise, because most wills are filed, they have to be notarized. That's why they have a notary there. Except an original will. A document except an original will that is filed. Yeah, I'm just worried about I'm worried about somebody doing an amendment to the will or something like that. Like you can have an original will and then the parent becomes ill. One of the 3 children is taking care of the family member and the other 2, and there's a big dispute over the estate. And then there's a modification made prior to them passing away. That's not the original will. And then we have somebody that literally hijacks the family estate from the other family members. Could that happen with the way this bill is written, Shamari?
It seems like it could,
Okay.
but
I got you. I know that's intent versus what's in black and white, or black and white are already 2 different things. So
Right.
I would, because of that, then I would move unfavorable or hold it to have their amendments considered.
Happen without it being electronic signature. I mean, somebody could, but that's fraud.
It is, but they normally would have to have it notarized and have the person there in front of them.
I don't know what the procedures are in this process, but I would assume that if they have to have it notarized, they would still have to be notarized under.
It
under this
doesn't
process, right?
specify that.
But it may not be, and again, I think we would probably have to look at the entire the article, and I'm sure it would have that somewhere. That this wasn't just taken.
But an electronic filing, there's no way to notarize an electronic filing.
I don't know about that because you have electronic notaries.
No, you can do e-signatures with like that. But I'm looking at it. So, I mean, if you pull up,
There's e-signatures, but not a
No.
notary.
no, I get it.
A notary has a raised seal. There's a reason you have to do it in
And a wet
person.
signature. I get it.
It's a wet signature with a raised seal.
No, I get it.
Has to go last year.
Electronic
Remote notarization.
Right.
So the notarizations can now be done electronically and remotely. This is
Better
nothing
ways.
more than a filing. It says, it talks about filing documents.
I'm just saying. Shamari just verified that there was a way that it would be an issue, and it's not clear to me, so I am not in favor of moving this as it's written.
Would it help if we change the language from accept an original will to accept an original will and any codicil or amendment to the original
lesson for
Yeah, I mean, there's layers too. There's multiple layers here. This isn't just one specific thing. When we start taking away, and if you were a part of that, then in my opinion, shame on you. When we start taking away the idea of what's required by a raised seal and wet signature, there's a reason that's been in place forever, is because we don't want to allow people, because how many people do we know on a daily basis that are having their bank accounts and everything else hijacked electronically by means that they're not even in their family? So the concern is that there's a reason that it's been that way for up until apparently last year, that you had to have a raised seal and a wet signature because it verifies the authenticity of the process. You had the person there who is affected by it most, who's the property owner or the will right crafter,
Right.
and signing off. And now we're saying that, oh, let's just do it by electronic signature. There's no way I would, that's a horrible precedent to try to set forward, that we would allow somebody who would be otherwise computer savvy to do something.
Well, we passed,
Illegal because of a
we passed
notary-
that bill last year. It was a very complicated bill with all sorts of nuances to it. It was originally put in place because of COVID. People could not come down and sit in a room with lots of strange people to sign documents.
Yeah.
So it was originally implemented by the governor by an executive order during COVID. But when all those executive orders evanesced,
And it's over.
evanesced, they needed a bill to do the same, because the Wilson Estates people realized this is good. You have people in nursing homes, they can't physically get downtown to the lawyer's office.
So you have a notary go to them.
All I can say is the bill was very complicated and lengthy. And we went through it all last year and we passed it. And this is not that bill.
I understand that.
Arguing about that bill.
Let's go to Senator Newton and Senator.
Can we just hold this until they can get some clarification on whether or not that can happen? I get involved with a lot of families at that time, and they for a TV and a telephone, they just go haywire. And so if we can hold this until we can get an answer.
Senators want to hold, you get a hold. All right, we'll hold it. Senator Sidnor, sorry, go ahead.
No, I was just gonna say, if you look at the testimony from these registers of wills, they all want it and address it and talk about all the other systems that are out there that are using e-filing. I suspect, and I can't speak to it because I don't do this, but I would suspect that the concerns that have been raised are going to be dealt with again, because they're talking about, at least in Baltimore County, our register of wills says our system would utilize a reliable, secure, cloud-based interface to make the probate process less expensive and more user-friendly through the e-filing and the signatures. So I hear I want to hold, but I don't really think there's an issue here.
We'll get clarification. We'll probably vote twice next week, so we'll get it out. Yeah. Oh, sure, yes.
The AARP is in favor of it. That would take care of any of the seniors that may have had an issue. So just FYI.
We got it. Still early in the game. We've got time. Yeah. All right. All right. So now we'll go with Senate Bill 277. Shamari's counsel on that.
Senate Bill 277 requires a judgment creditor to provide notice to specified individuals and entities of the time and place and terms of the sale of any real property under execution before the property may be sold. The judgment creditor must also file an affidavit regarding the notice. The sheriff's sale of real property that complies with this bill and existing statutory requirements extinguishes any subordinate lien or interest in the land being sold. The bill also authorizes the use of an assessment record in lieu of an appraisal in specified circumstances, and specifies that existing prohibitions related to exemptions do not impair a lien on land affected by a judgment in favor of a local government for real property maintenance violations or nuisance condition violations that is indexed and recorded in accordance with the Maryland rules. As amended, the bill would delete the option of using the assessment record in lieu of an appraisal. And so the appraising of the property would be with the sheriff. So this is addressing that the and Senator McKay can chime in here if he wants, but it would address blighted properties and allow them to be sold by the sheriff for creditors that have interest in the property.
Are you the sponsor of both of these amendments? Okay, the first one basically strikes out all the notice provisions.
But now that taking the notice part out of it, we had the city solicitor who came and testified, Mike Cohen, talked to SDAT, so that took care of that issue. And then who was the other one, Shamari? The IO. Maryland Legislative Active Committee. Yeah, and so we were able to strike balance with them and the other So there's no opposition now. It's all been taken care of.
All right, so let's go through the First Amendment, amendment 443021/1. That's the notice provision. Just can you explain that before we vote on it? Shamari. please.
So the amendment number one, just takes out the notice from the title. It's a technical amendment. And then the other amendment is, or sorry, the other part of amendment number one is, sorry, maybe looking at the wrong reprint.
Correct.
Senator, okay, would you mind, why would they want to notice? What will they if you were to notice?
So first of all, SStat, no, the SStat was on the. Hold on a second. So SStat at first had the issue with the.
They had an issue with the use of their assessments
Correct.
for the
Right.
appraisal of the property.
They had said that appraisal shouldn't be used, their assessments shouldn't be used as assessments. So we worked with them. And then the community, the Maryland Legislative Action Committee, Community Association, they're the ones that had the issue and taking out the notice. Well, when you have blighted properties and it's all been identified for it, the sheriff is involved with it with the notice. And it says about having the sheriff put in the appraisal. So by removing the notice part of it takes out. I'll have to get a little bit more clarification on it.
That I think was being obligated to provide written notice, and they didn't want to have to do that because they were saying it's the sheriff that I think was in a better position. Was that what?
Correct.
Okay.
Yeah, actually, I like the notice provision. Because there's no place in the code right now that all this stuff is laid out. You have to go back to old court decisions to figure it out. And years ago, my office was involved in a foreclosure. And the young associate assigned to handle it did not send notice to to one of the other judgment creditors, a junior judgment creditor. It got all the way through the foreclosure, and then the title company refused to pass an insured title for the person who bought at the foreclosure sale because the judgment creditor had not been given notice. And I went back in the code to try to find where the requirement was, and there is nothing in the code. You had to go through old court decisions to figure that out. So I sort of like the fact that this lays it all right out here in black and white as to exactly who you have to give notice to.
So if you look at page 2, there's notice that's provided under A, which says the sheriff shall give notice. Right. So I mean, there is some notice. But I guess this particular notice provision was the judgment creditor, them being obligated to provide the notice that.
Remember, the judgment creditor is the one who's doing the foreclosure. And so what this says is if you're going to do a foreclosure, before you do the sale, here's who you have to notify: A, B, C, D, E, F, and G. And it just seems to me reasonable that the judgment creditor who is instigating the foreclosure sale should have to notify everybody. But the key is that they know who they have to notify, that it's laid out in statute, and not they have to guess who they have to notify and go through old court decisions to figure that out.
I disagree with you. Right, that's what we're arguing.
That's what
about
we're,
the amendment.
do we really want to strike it?
Right.
Right.
I think most of us want the notice.
Yeah. Take anybody's property,
Yeah, so forget the judgment notice.
Government in dealing with blight. It's just not, it's not general.
Record already across at various jurisdictions, and they all come forward and ask. This is a statewide bill though. The blighted bills that are in place to be adopted by local jurisdictions, they're pretty, they're like, I think they said one time there's like 33 municipalities that have it. We just authorized it to the town of Mount Airy, but this is a statewide bill, and we're talking about taking away required notification for people that take their property.
I mean, at the end of the day, this is redefining what the sheriff's sale process is. And presently, there is no requirement for a pre-sale notice to be specifically directed to property owners and others with interest in the property being sold. So right now, there is no.
Is this for an issue that you're having, one of your
This
counties
is, yeah, this
having
is
out west?
Yeah, no, yes, but it is statewide.
I understand.
It's a statewide issue because the clarity isn't there.
I mean, he's right in one sense, like the notice that they're striking out was all new anyway. So it was never on the books. The notice now is not directly to the judgment creditor, but it's like through a newspaper publication on the courthouse, that type of thing. So he was adding more, but now he's taking it out. So it's not like he's taking anything that is currently on the books off of the books.
But
And if you're a judgment creditor, you're gonna do your due diligence and look into the publication, like the Daily Record and the court.
I just think that the part that's being taken out, which was the part that was being put in.
Yeah.
It only gives instructions to judgment creditors. It places no obligations on the county courts, the county system, the county sheriffs, anybody. It only places requirements on the judgment creditor. And the key is that it puts into statute and makes it clear exactly who the judgment creditor has to give notice to before the sale occurs. Otherwise, without this, the judgment creditors have no idea unless they go back into old court decisions and figure it out. This puts it in writing, so they don't have to figure it out. I just think this makes every bit of sense.
And at the end of the day, both amendments take care of any opposition that was on this bill.
We ain't worried about opposition.
Then my work is done.
I've never seen this before. He puts in a bill and then an issue that's inside of the bill that he takes out that was not an issue, or the subject of the bill hearing is now an issue that's gonna sink the bill. It's not gonna sink your bill. We'll figure it out. Yeah.
I think what you hear is that we're all on your side on how you put it in.
Yeah, we like the original bill. Go with it.
We like to.
Mr. Chairman, I think this is a great bill. I love the bill. What would be the process? This county out.
Right.
It depends on which one we. Not even.
I think we should have a further discussion on it because there's something here that we'll hold it. I tried. All right. Did we do 196? We already did 196, did we?
No.
Oh, that's the last ground rent. Shamar, are you ready or do you need to?
Yep.
Okay, let's do Senate Bill 196.
So Senate Bill 196 repeals a prohibition against a leasehold tenant who is seeking to redeem or extinguish a ground rent, providing certain documentation and payment to the State Department of Assessment and Taxation earlier than 90 days after the application for redemption or extinguishment has been posted on the department's website. And so this was requested by SDAT because, as the law was previously, if someone was trying to redeem or extinguish a ground rent, if they their request would be denied if they posted it too soon. And so this is really just clearing that up, or if they pay the escrow or pay the fee to extinguish it. If they had done that under existing law before the 90 days, it would be denied. And so this just allows them to post the money sooner and not be denied for essentially complying with the requirements too soon before it's been on the website for 90 days.
So essentially, SDAT said that this is a 2007 drafting error, and as council noted, because of that drafting error, if they didn't get a payment within the 90 days and they got it before because you were trying to be dutiful and pay, they would have to reject it, which makes no sense.
Motions for favorable has been seconded. Everyone is okay? All right. Senate Bill 196 passes. Okay. Do you want to, Shamari, one more time, and then we'll move off we'll go to Josh. So Shamari, let's go to Senate Bill 195. And then Josh, we're going to go to Senate Bill 147.
Senate Bill 195 requires that candidates for judges of the Orphans Court appear on the ballot without party designation. It also adds a new subtitle that governs Orphans Court elections.
We currently elect circuit court judges. This just elects orphans court judges the same way. If in each county, there are 3 orphans court judges to be elected, if 9 people file, all 9 names go on each of the Republican primary and the Democratic primary ballot. If the same 3 win both primaries, there's effectively no general election. Those 3 are the 3 names in the general election. If A, B, and C win the Republican and A, B, and D win the Democrat primary, then A, B, C, and D, all 4 appear on the general election ballot alphabetically without regard to party affiliation, and the voters will elect 3. Yeah.
So there's been a motion for favorable. It's been seconded, but Senator Washington has a question. So before we proceed, we'll go.
Yeah, I was just gonna ask if the Board of Elections took a position on this, or have they sent a letter?
They've taken no position. The orphans court judges have taken a positive position.
Okay. Cool. Okay, thanks.
All right, so it's been seconded. Do folks want a roll call, or is everyone? All right, everyone's good. Okay. So Senate Bill 195 passes. We'll now move on to Josh.
Senate Bill 147 increases penalties and points assessed for violations related to participation in racing or speed contests. The bill also establishes a statewide prohibition on exhibition driving, where it basically imports the definition of exhibition driving that the committee passed and the General Assembly passed, I think in 2020 for Worcester County. Additionally, the bill authorizes a police officer to order the towing and impounding of a vehicle that is driven in a race or speed contest or exhibition driving. There is an amendment in your packet that's number 103720/1. What the amendment does is it removes the additional penalties in the bill for causing death while racing or exhibition driving. And the reason for this is there's a possibility that those convictions, if you cause death while in a race or exhibition driving, that conviction would merge with the offense of vehicular manslaughter by gross negligence, which carries a 10-year penalty as opposed to the 1-year penalty in the bill. So in that situation, someone would only be able to be sentenced on the 1 year in the bill rather than the 10 years for the vehicular manslaughter offense. So in the bill, so there's an existing offense of street racing and then there's an existing offense of causing serious injury in a street race. The bill adds causing serious injury or death. So if you were in a situation where you were racing and somebody was killed, you would have committed both the offense of causing death while street racing and the offense of vehicular manslaughter by gross negligence. The way that merger works in Maryland is if you're convicted of essentially the same offense, except that one offense is more specific or has an additional element, you can only be sentenced on the more specific offense. So because street racing involves the more specific element of being involved in a race as opposed to acting in a grossly negligent manner, you would only be able to sentence to the 1 year in the bill as opposed to the 10 years for gross negligence manslaughter. Right.
Ensuring that the two charges don't merge. Yeah, but we're not touching that. I mean, this bill doesn't touch that. Can we at least adopt? Let's adopt the amendment and then work off of that. Second, is everyone okay? All right. Okay, so on the bill as amended. Oh, okay. Motions for favorable seconded. Everybody knows what they're doing. Okay. Is everyone okay? No further discussion required or needed. Okay. That bill. Bill passes. Is everyone okay? Want to do roll call? Okay, all right. All right, so the bill passes. I'm just, that's a significant bill. Yes, yeah.
Not by those amendments, it still allows the person to be sentenced to the longer.
Yeah, oh yeah, yeah. That's why we fixed it, because otherwise you would have just gotten the 1 year sentence. Okay. I mean, it's working magnificently in the Eastern Shore, but and it has not been misapplied or, some of the concerns we had last year when we messed around with the language, adding two elements. I know.
We're expanding an existing.
It's an existing. It only exists in one jurisdiction in the state, which is Ocean City, Worcester County, the entire county. So we expanded to all 24 jurisdictions. It's going to help in Montgomery County for sure, just the street racing, but it's not. It's not. I'm not saying it's like a game-changing thing, but it's not insignificant. What allows impoundment of your vehicle, and if you go on page 3, it defines what exhibition driving is. So there's a definition now defined.
So let me ask you this, because pointing that out, because to be in violation of aggressive driving, you have to.
And you can now be arrested for this.
You have to meet the integrated areas. And if you don't meet 3 of those areas, you can't be charged with aggressive driving, which is not an arrestable offense. But this is now becomes a must appear arrestable offense.
Yeah, so there's a 60-day penalty, so it is arrestable.
So again, I just want to clarify. So for a street racing contest, that does not, is this only if it results in some type of injury or no? This is just street racing. If you're stopped in the street race, because I think we got kind of in the weeds there and we started talking about death. But I understand that, but what I'm saying is we kind of talked about that, and I think people may have misconstrued that for being a part of this. And now when I'm reading through it, it doesn't say that a vehicle that exhibition driving, and it says that the excessive or abrupt acceleration or deceleration of a motor vehicle. It doesn't say that you have to meet so many of these things to be considered exhibition driving. It just says that you have to do this. And that is a very subjective element that you're putting, because now we're looking at towing and arresting someone for the idea that, oh, that looked like that person accelerated too fast. Because I'll tell you right now, thank goodness, my wife get locked up by this, because she is known to pull away from a stoplight on somebody that's beside her, eyeballing or irritating her. She'll be like, I'm getting out of here because I don't feel safe. So by that action alone, the way this is written, would that not be an arrestable offense?
Look, that is exactly why I said it's not an insignificant bill, and it has not been, it's not been misapplied in Worcester County, but
when you're looking to make this
you're voting on.
statewide and you're leaving it quite subjective, and we don't even have a penalty associated like this with felons in possession of handguns.
So let me start, because I was a skeptic of this bill when we passed it for Ocean City. Because Ocean City has lots of incentives to abuse this, because A, they've got police officers who are seasonal and less experienced. B, the people they were alleging were doing this are from out of town. They're not locals. And so they had, in my mind, I was skeptical of voting for the initial Worcester County version because I thought it could be abused. And I thought it would be abused. And in fact, none of that has come true. And the department with the most incentive to use the subjectivity has been, in fact, very much restrained in their use. And I've been impressed by that. And that's what makes me feel comfortable taking it statewide. Meanwhile, on the other side, in the chairman's district, which is right next to my district and which is frequented by people who live in my district, we've got people in essentially a pedestrian walkway, doing donuts around on that walkway. And the police are unable to enforce against that vehicle because it's not an arrestable offense. In my view, I don't think police are going to be arresting people under this, but providing an arrestable offense gets them to the impound. And that is really the incentive. The reason this has worked in Ocean City is not because of the threat of arrest. It's because of the threat of impound. And Ocean City has been really successful at dissuading dangerous car racers and other display driving from coming to their city, because when that happens, people know that their car will be impounded. So I'm comfortable with the power. And after living with this for a few years, I've turned from, I think, a really stark skeptic into something more akin to an advocate for the bill. So that's why I'm going to vote yes for it.
No, I mean, literally, the people they would hold up their citation and continue driving. And it has worked. But let's go. I'm gonna get you. Senator Washington was up, and then I'm gonna come back to Senator Fulton.
Yeah, I haven't, I mean, look, I'm just looking at the bill. I don't know if I was here when this bill was up for public hearing. I guess my major concern is that I haven't heard from our state's attorney's office on this bill or around the state, how they feel about this increased penalties and the possibility of arrest for perception of racing really fast. And so I'm concerned by it. And so I know that we kind of voted, but I would like to, because of the increased penalties and things of that nature, I'm gonna change my vote on this. Yep. I mean, I can still just change my vote here. You don't we'll have to do that, but yeah. Okay, cool.
Does this, what we're talking about, this provision for arrest only applies if someone is killed? It applies just because you take off fast?
It applies under those areas, and it doesn't require a combination of those events. If you're driving right now on the highway and you get to be charged with to be charged with aggressive driving years ago, you have to hit 3 of those enumerated areas, and an officer has to observe 3 of those infractions in a succession to be able to even be charged with that. And it's not arrestable. This, and I don't know what the issue, and I apologize, Vice Chair, I didn't hear, you said something, was it about a crosswalk or I was,
He's in a town square, but it's basically a pedestrian.
right, sure. But so when you look at this, understand, we want to do everything we can. We've stripped police officers of a lot of responsibility and subjective, discretionary decisions just in the past 3 years. But on this one, this is one of the most subjective definitions that I've probably ever have seen in any law that could end in and is an arrestable offense and impound their vehicle. Because if you get pulled over for DUI, do we impound your vehicle? Does anybody know? Oh, no, it doesn't have to. If it's off safely on the edge of the roadway, it can stay right there till somebody comes gets it that's sober. We don't have to tow it, which they were driving impaired and endangering other people's lives through that impairment. But on this one, by virtue of this, you can take their car and tow it. We're trying to make a financial burden on our citizens that is unnecessary on a subjective matter, because it says, this is the definition. What would, I implore any of you to please clarify the language for me. What would be considered an abrupt acceleration? An abrupt deceleration. So if an animal runs in front of my car real quick and I jam my brakes on, have I not done an abrupt deceleration? Also, unreasonably loud. Somebody defined for me in the letter of the law what would be deemed unreasonably loud, because that is a subjective statement. That's a subjective definition, because unreasonably loud to me, I don't hear that well as it is. May not be that much. If it's Senator West, he'll never hear it. But if it's, if it's somebody else like the chairman, it might be, or the vice chair, it might be something that's nominal. It's a subjective standard. A disturbing noise. You know what's disturbing noises to me? Some music might be disturbing to me if that's somebody's playing. And then the backfiring of an engine of the motor vehicle. Now, there are mufflers that are made to reverse and create a loud pop, 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 pop as they're going down the road. But if I have a 1976 pickup truck that I haven't done my due diligence and taken care of the muffler or the undercarriage of the vehicle, and it lets out a pow every time I shift gears because it's just an old vehicle, that by this standard, they could take my truck, lock me up, and impound my vehicle. And then the final point is, it says transportation of a passenger on or in an area of the motor vehicle that is not designed or intended for passengers transport, such as the hood or roof. However, is the bed of a truck designated for not having any passengers, or is it legal under the law, if you're 16 or older, to ride in the bed of a truck? Because by the officer's interpretation, it may not be safe to be in that vehicle in the bed of a truck. But you can ride and transport people in the bed of a truck, because they do it all the time on little parades in small towns all across this state after they won a championship or an opening season ceremony. By this definition, we could lock up that truck, the person driving all those kids around, and take his truck.
Thank you, Mr. Chair. So, the Maryland Chiefs and Sheriffs Association is in favor of this. The public defenders is against, state's attorneys against, NAACP for it.
It's all over the place.
So we can create all these different case scenarios, but at the end of the day, the issue was brought to light in Worcester. There were some concerns when they passed it. Those concerns haven't come up. So we can sit here and we can create all kinds of case scenarios of the what if and all that kind of stuff. But the case has been shown it's working.
Oh, so I was just gonna clarify. I think the state's attorney's opposition was because of the merger issue. If I remember correctly, that's all they were weighing in on. Just to clarify. Correct.
That was my question.
I just want to make a point and that I think you could clear up. I think you have very valid points. I'm sorry, I did not read this as carefully as I should have, but one, I think you have to distinguish in the language between intentional versus inadvertent. And then I think and let me think about it for a little bit, but I think you could come up with just some language about it not being momentary. I get my colleague's point about somebody just pulling out of a full stop, maybe at a traffic light to get away from something or to abruptly brake because of something. But I think if there could be a few word modifications here that would probably clarify your concerns. Would be my suggestion that we think about.
I'll just finish with this, Mr. Chairman. Element of law is very black and white. And when you don't have a combination of these, but it says basically any one of these enumerated areas. And to have 1, 2, 3, 4 of them be so subjective that there is no measurable standard, because any element of law has a requirement that there is a measurable standard of the offense. This doesn't go by decibels. This doesn't go by how many backfires. This doesn't clarify what an abrupt acceleration is in a time frame or a distance. It is such a subjective manner. You are putting police in a trick bag, because then they're going to be engaging with the public, and then you're going to have more complaints against law enforcement because they sat there and said, hey, I didn't go that fast. I want to file a complaint on this officer because it was so subjective, and now he's upset. We're trying to create a statewide law, or we're expanding this statewide because Ocean City was having some racing issues. That's great. But if we're having issues within the municipality or within Montgomery County, then we should be seeking to get the utmost clarity, because in those jurisdictions, you need to give the officers the ability to stand up and make not a judgment call, but something that is defined and clearly defined in law, in statute, to be an enforceable standard. And none of these are an enforceable standard. It's subjective. We're putting standards in there, but it's too subjective, and it causes problems for the citizens that we represent, and it causes problems for law enforcement to get more complaints generated out of this type of activity. And that's what we don't want. We've been doing everything we can to kind of bring our community and law enforcement together and try to have this understanding. And by this bill itself, we're putting law enforcement and we're pitting them against these people that we're saying, all these young kids who like to take care of their cars. And, and this doesn't even say about the operation of a motor vehicle that results in, the disturbing noise. What's a disturbing noise? It's so subjective. So for those reasons, I would implore all of you to really look at a measurable standard, because anybody, Senator Sidnor and I, we've had some really good discussions in the past about traffic stops with police. We have, haven't we, sir? And because of that, would you ever want any of these things that are not measurable and clearly defined be a reason to allow you or your children to be stopped? And if the answer is any of these could be because you had a backfire, or that's just not a good thing to go down. That's not a good rabbit hole to go down. We're going to create more problems than we're solving.
The senator makes some good points.
Yeah.
I mean, seriously.
I would like to document, we have that journalized.
Look, all right, so that's why I know we did like an oral thing, but that's why I kept it open for the debate, because this was not change, but it's not insignificant. So I'm glad we had the further debate. What I'd like to do then is to do a roll call for the amendment, okay? Because the amendment satisfies the merger issue, and then we're going to hold the bill, do further work on it, see if there's anything we can do. I think it's an important issue because I can't go home this session without doing something about exhibition racing, because it's happened like 3 or 4 times in my district. It's extremely dangerous. And people, that might be something I'm looking into. I don't know. We'll see. But it's also a senator from Anne Arundel County's bill. So let's look. I think we can fix this. We can do something with this. So let's do a roll call on the amendment. And let's get the amendment number out. Josh, do you have the amendment number?
Number 103-720/1.
All right, so we'll take roll if you could.
Yes.
Senator Sidmore,
On the amendment, yes.
Senator West,
Yes.
Senator Muse,
On the amendment, yes.
Senator Folden,
Yes to the amendment.
Senator James,
Yes.
Senator Washington,
Yes.
Senator McKay,
Yay.
Chair Snee.
Yes on the amendment. All right. Amended Senate Bill 146 amended. We're going to hold it for further review and work.
147.
Yes, Senate Bill 147. Yep. We passed 150, right? Yeah. All right. So we have Senate Bill 21 is left and
106, 190.
If I need to print 21. I was asked to. I'd like to hold 21 till next time. I'm trying to find other states that have similar laws and see how they handle this problem. But the people who are supposed to be researching that in the library haven't gotten back to me.
Senate Bill 190. What is the Judicial Proceedings Bill? No, the other one.
190 Spino?
Yeah.
Okay.
Tweet one.
Oh, the circuit.
Yeah.
Shamar, I guess that would.
While Shamar is looking for that, let's go with Senate Bill 211, because I know that Senate Bill 220. There's some people that want to have some debate on that, so we're going to hold that. Which one was it? Okay, got it. So we'll do that in a second. Let's do Senate Bill 211. I think that's an easier lift. If not, then we'll hold it. But let's start off with, let's do 211 and then we'll go to Senate Bill 342, which is not on the list.
Senate Bill 211 authorizes a court to place a defendant on probation before judgment if the court finds facts justifying a finding of guilt and makes corresponding statutory changes to account for the authorization and establishes procedures and requirements for a probation before judgment granted under this circumstance. So there is an amendment in your packet that's number 793523/1. The amendment clarifies that the defendant pleads not guilty in this situation and that the court has to find facts justifying guilt beyond a reasonable doubt. The amendment also adds a requirement that the court find that it is in the public interest, or rather in the interest of public welfare, to engage in this procedure.
The amendment is at the request of this, well, to solve a problem raised by the state judiciary. So I think with this amendment, we've solved the problem. Well, you know, the standard for criminal convictions beyond a reasonable doubt. And so as originally adopted, the bill said that the court said the facts would establish guilt without the words beyond a reasonable doubt. So now the court would have to find that the facts are sufficient to find guilt beyond a reasonable doubt, which would justify a judgment.
I find it ironic that we're talking about proof beyond a reasonable doubt on this bill, but we had a bill just before this where we have a very subjective standard of guilt, but.
So my understanding is that the State's Attorneys Association and in particular your state's attorney, as well as the Maryland State Bar Association, have amendments that we have not seen. And so, yeah. Yeah, would that be okay?
Sure.
Okay.
All right, so
Who should I call?
I think Josh.
Oh.
okay.
I haven't
Well, for-
received anything, but we can have those.
We'll reach out. All right, so we're gonna hold Senate Bill 211. Senate Bill 220 is being held. So let's go to Senate Bill 342, which again is not on the list. 342.
Yeah. Senate Bill 342 increases from 20 to 21 the number of circuit court judges in Baltimore County. The judiciary is requesting the increase in the judgeships because of increased case filings in the past 4 months.
Motion for favorable has been seconded. Is everyone okay? The bill passes. Senate Bill 342 passes. That's the end of our list.
106.
Yeah, of course. Good catch. Senate Bill 106, and that is
That's me.
Shamari.
Senate Bill 106 exempts $500 in a deposit account from execution on a money judgment. This is inclusive of the $6,000 exception that a debtor may exempt from execution. As amended, the bill adds a definition for depository institution, and for clarity indicates that the $500 is included in the $6,000 total that a debtor has to elect to be exempt from garnishment. And it clarifies that an institution may not be held liable for good faith reliance on instructions in a written garnishment. And it establishes procedures that banking institutions must follow on receipt of a writ of garnishment, attachment, or levy.
Did we get clarity on we were talking, and I don't remember the exact language that was used, but it was about a snapshot versus like a continuing. So
Yeah.
did we get clarity on that?
So the new language, which was submitted by Bob Benton and agreed to by I keep EEAC, I believe, is in here. So what the amendment does is it creates the snapshot system.
And that was, and I'm gonna ask one second piece here, because this is not within my, bailiwick of expertise here, but so the snapshot, having that amendment, it still affords the person to have $500, but are they allowed to go back then and without only that one time and try to regain or make for the judgment, or do they have to file each time?
The snapshot means that the bank has to, it's a snapshot. It's the bank takes a look at the bank account when they get the garnishment, and they do whatever they do in response to the garnishment, click
At
that
that
one
time.
time. They don't have to continually look at the bank account week after week after week.
But if they don't get how much, I guess they're trying to,
Then the person who got the garnishment can get another garnishment. And the
They can
bank
do
would have
another-
another snapshot. to
so
answer
there's
quickly.
separate paperwork each time, or is this
Yes.
just a continuing until the,
It puts the burden on whoever wants the garnishment to do the paperwork, and the bank doesn't have to continually, day after day, week after week, look at this bank account
Okay.
and then do paperwork.
thank you.
But the first advantage for that, if you're the collector, you don't take a snapshot.
Correct.
Because someone's check is.
Yes.
There's
pros and cons.
Money comes in and it goes out, the bank misses it, then the banks don't want that either. It's not fair.
No, I get it. I'm just saying.
And I guess that's what my question was, or my concern is that, so now if you're the trying to execute and I guess recoup your debt, you've constantly have to go and file paperwork every time to obtain the snapshot, and you obtain that snapshot through the bank at that time or through your own source? Like, this is, I mean, the bank is included in this, the way I understand it, at regardless. So I'm calling for a little insight here on it, because the way I understand it is that they would have to be crafted up each time in a snapshot. And then the snapshot would be then executed by the bank, right? Because the debtor doesn't really have the opportunity to go in and see their account. So they're going to be relying upon what the bank's telling them is available.
And not only telling
And
them,
then-
paying to them.
Yes.
Taking out of the bank account and giving to them in response to the garnishment.
So I guess my point being is, and it's a valid point that the chairman makes in conjunction with that is, so say if I have no, I'm saying the scenario, this is what I want, this is what I don't want to have happen. So if we go in on, say you do what we're going to see is that they're not going to make a snapshot in the middle of the week on a Wednesday.
Good.
They're gonna
If they get the garnishment on Wednesday, they do the snapshot on Wednesday.
But they're going to wait till payday.
Well, you mean the the person getting the garnishment would wait until payday.
Correct.
Exactly.
So when they make that, they're gonna, every 2 weeks, they're just gonna have it in their calendar to make that garnishment request and have it, and they could literally, every time the person got paid, take everything except for $500.
They could do that. Right. That would,
So is that
garnishments
better?
aren't free. You got to pay money to get a garnishment. So whoever is doing the garnishments would have to pay that price every time they file a new garnishment.
And that's the other thing. So because it is a snapshot, we're requiring them, instead of before it was an open, that the bank was just actively monitoring it until the debt was paid.
Right.
Now we're having them pay additional fees for each snapshot every time to collect their money. And how much is a garnishment fee?
I don't know what the filing fee is. It's.
I mean, I don't know.
at
some point I would be curious to hear that too. I would like to know what that amount is, because at some point, I just want to have a balance here. I don't want to keep adding additional fees through snapshots versus a holistic, approach of, okay, well, this is going to be open until such time we set up a fee schedule to pay them back and we have it taken care of. What I don't want to have happen is that the institution is like, oh, okay, or the debtor is like, you know what? We know they get paid on every Friday on this every other day, or on the 1st and 15th of the month. So we're just going to go ahead and file it that day. And what we've done is we've actually put them in a situation that it's almost becomes not economically feasible to go to work. Hi.
I'm always, okay. I know not to touch it now. Kat Highland on behalf of the Office of the Attorney General, Consumer Protection Division, and the Consumer Advocates. Here to help answer any questions on this. I don't know the filing fee off of the top of my head, but I know that it's filed into a district court action that's already open. So it's not like you have to pay a filing fee to start a case. So I think it's something smaller, like $25, but we're happy to check on that. Every time they file the request. But I just wanted to point out that the creditor can't control when they get the approval from the court to send out the writ of garnishment over to the bank, because they ask the court, and then the court sends the writ, out to the bank, or the court sends it back to them to send out to the bank. Right.
Is once that request is made, then you can do your snapshot whenever you want, and it's usually turned around on the same day.
Well, and my impression is the bank doesn't have an interest in saying, I'm going to do it on payday, and the creditor can't control when the court is going to say,
So
you can have your garnishment.
So we have a bank. So we have a bank
get to
then that would be, we're giving the bank, we're removing them from any liability or what we're saying, but we're also giving them the ability to not apply or not take the snapshot at a time when there's sufficient funds to be there, thereby giving the person more time to move the money out to another account.
Well, the bank should just, as the senator said, grant write up the snapshot when they get the writ. That
Correct.
day they should just see what's in the account and issue it. There's no
Correct,
discretion.
but what you just said that it could be different. Like there's no requirement that they do that at that same day. It might be a day or two later if there
Right.
is.
And in practicality, it's not going to be the exact day that the court issues it. It's going to be whenever the bank gets it. in the
But they
mail.
don't need to get a court action every time they ask for the snapshot. The court action is the opening portion of this process, and then they can go back in once that court option or that court action is made, and they can ask subsequent to that for these snapshots as many times until the garnishment is collected.
But that still has to have a writ granted by the court each time. So the bank is responding to the writ that they get from the court each time.
Well, that's different than what we were told. That's different. If you've got to go to a court every time to get a writ,
It's a perfunctory act, but there is administrative procedures to issue the writ. So if I apply for the writ on a Wednesday, and typically you send it in by mail, excuse me. I apply for the writ goes to the court. The court takes some time to process the writ. The writ gets processed, the writ then gets served on the bank. Who knows? There's no way that the person asking for the writ can control what day the writ gets served on the bank. When the bank gets the writ, it opens up the bank account files, finds exactly how much money is in there, and then cuts a check for whatever they're entitled to and sends it back, right?
They freeze it at that point.
They
They
freeze it,
freeze the
okay.
amount and they file an answer with the court saying this is the amount of money in here. The creditor then has to file another document with the court saying, I'm requesting judgment that be released to me. And then that's the fixed amount.
so how much is each of these actions? Every time you go to the court for this writ, how much does that cost?
They're nominal filing fees. I don't know what they are off the top of
And
my head.
then after that, there's an additional fee that has to be paid to the bank.
No.
No, the
No.
bank's done at that point. They just have to answer under statute.
They have to
hold
answer
the
under
money
statute.
And then release it.
I got
So
it.
the
here-
money's frozen until the judgment comes in.
Let me just
releasing it.
throw out this observation. Maryland has always been a snapshot state. We are not a continuing state. If
Mm,
we were a continuing state, any logical,
That's,
I
that's not-
respectfully disagree, but I
That's
don't want to
not
interrupt
accurate.
you.
Is that
That's
that's not
We
accurate.
have not been.
we have,
This will make us.
So currently under the
Yes.
Maryland rules, the rules provision on enforcement states that when the creditor asks for judgment, they can ask for anything from the point of the garnishment up to what the judgment amount is that's in the account. So this would change that and say the bank only has to give what was in the account on the day that they received the writ. So they freeze it on the day they receive the writ and they file their answer. But in the status quo, the creditor can say, I want everything from writ date through today, the day of the judgment, up to the point of the amount that I have. Sorry if that's.
No,
I'm
no.
confused. So you're saying that the bank has an obligation to continue to monitor this account on an hourly or daily basis? And keep taking money out as the weeks go on?
They don't take that, they just freeze it. So consumers get really confused because they think the money's gone, but it's actually just frozen up to the amount of the judgment in their name. So if they have a judgment for $1,000.
In that situation, wouldn't any logical debtor simply open a different bank account in another bank that the creditor doesn't know about and put money in and stop putting money in this account?
Yes, and in my experience representing consumers, that's what they do. They stop using that account.
Exactly.
So it's administratively complicated
It's a
for
mess.
everybody.
Okay.
And the snapshot does benefit the consumer in the short term, but a logical consumer will likely still not trust that bank.
Right. Exactly. Okay. Thank you.
This might not be, it's not really relevant to, I think, whether we support the bill or not, but the $500 is part of the 6,000,
Yes.
right? And then, people can have more than one garnishment in their life, and I just wanted to know that 6,000 is a per garnishment or a maximum lifetime protection, and how would the 500 be viewed as well?
It's per judgment.
That's what somebody in this committee
I
said you
did
can
ask before,
right?
yeah.
And that's completely wrong. You can have more than one garnishment, but in each garnishment, God forbid you do, but life's weird.
Yeah.
You get a separate $6,000 protection,
Mhm.
and then in each garnishment, you get this $500 protection.
Well, so I'm just gonna
Or
tweak your
is
wording a
that how
little
it
bit.
works?
So you can have many garnishments on the same judgment, you know what I mean? Because a creditor goes and tries to find all your bank accounts. So they file a request for garnishment
I
on
didn't
one
mean to
thing and
confuse you. I meant
you just so we're clear.
you were early in your life, you got into a lot of trouble
Yeah.
and got a bunch of garnishment, full stop. 20 years later, separate situation. In that scenario, does the $6,000 protection apply to each of the unfortunate instances
It
in your
does.
life?
Yes, because they're all separate contracts with
Right.
separate creditors.
I just think in this committee, someone answered that
was-
very differently, and I wanted to clarify it for
Yeah,
people.
and the question I remember was
Yeah.
comparing this to bankruptcy court,
Yeah.
because in bankruptcy court, you have a certain amount that you can exempt up to every 8 years of your life, and that's tied to the debtor. This is not tied to the debtor in that way. It's tied to the judgment.
Yeah, thank you.
So we're gonna hold Senate Bill 106, and the sponsors amenable to that. We'll keep working, we'll get it. But this is very good. Thank you for the information, because especially the last point for Senator James, that I think we were all confused about that.
Yeah.
Okay.
that was
All right.
confusing.
So with that, the vote is now closed. And that'll end.
Thank you.
We're gonna hold, I'm sorry?
Yeah, good for her to be here.
Yeah, no, good.
We know you're
All right.
not.
We'll
That's
close it up.
good.
All right, it's closed.
Oops.